Good morning, everybody. Good morning, good morning. How are you guys doing? Other than the fact that it's really early for Las Vegas, has anybody not been to bed yet? Besides me. Dave, I totally expected your hand to be up on that one, sir. Welcome to everyone. We are having a panel this morning on the do's and don'ts of collateral recovery. I will tell you it's better than doing an accounting topic at 4 o'clock this afternoon. Fortunately, I got out of that duty this year. So, welcome to all of you. We are recording this session for future download through our site. So I'm going to ask you for your questions, and there better be questions because it's going to be a really short discussion if you guys don't ask questions. That's what panels are all about, right? See the microphone in the middle of the room? You don't need to raise your hand, you just need to come up to the mic, but please go to the mic. For one thing, if you try and shout from the back row, I won't hear you, and then I won't be able to repeat the question. We got to get the questions recorded as well as the answers. Everybody good with that? Do I need to tell any jokes? I don't know any clean ones. Nah, really, I don't know any appropriate humor whatsoever at 8:30 in the morning in Vegas. I would like my panelists to introduce themselves to get the ball rolling. I look around the room, I see an awful lot of faces in here and familiar faces, and there's a lot of kindred spirits in here, gentlemen, on the people that want to do recovery correctly. So let's start with Mr. Brown and work our way down.
Am I on? You all hear me okay? Okay, let me get something straight with you right off the bat. I'm not a cowboy. I hate cows. I'm a horseman. I've been in the business since 1973. I have a law enforcement background. I worked for the government in Vietnam for 3 years, came back. I was with U.S. Marshal Service for 3 years, went to work for the Texas Rangers. I still carry a Ranger commission. My office is in Oklahoma City. It's confidential security investigations. We specialize in asset recovery. I facilitate a 20 group, Eagle Group 20, probably the top 20 repossessors across the United States. I'm also one of 3 people that's certified as expert witness in wrongful repossession cases. I've testified against auto dealers. I've testified for auto dealers. We have a saying, right's right, wrong's wrong. There ain't no in between. And that's what I'm here to talk to you about today. Ain't no in between.
Thanks. Good morning, everybody. My name is Rob Sickles. I'm an attorney from Tampa, Florida. I represent like 450 auto dealers in Florida, some in Georgia and some in Ohio. And then I also represent finance companies. A lot of the dealers have related finance companies. And then I also represent some very large debt buyers as well as some standalone banks and finance companies. So I've got a substantial amount of experience dealing with repossessions when they go wrong and less experience when they go right because technically I'm a litigator, so nobody calls me when it's done right. But I'm happy to be here, and hopefully we can have some good discussion about the topics.
My name is Mark Naiman. I'm currently the past president of the Receivables Management Association International, which is the nonprofit trade association. It's made up of debt buyers, collection agencies, law firms, vendors, and the other associated parallels within that space. I'm the co-founder and president of a company by the name of Absolute Resolutions Corporation. We've got 2 offices, one in Minnesota, one in California. I've been there 20 years. We're a national debt buyer. We have, over the course of 20 years, probably evaluated $20 billion in inventory. We're not as big as the publicly traded guys, but we've been around for a very long time, and we've got a lot of experience on the auto side, not just from a collections and recovery standpoint, but also from a litigation standpoint. So very happy to be here, and so glad everyone's so cheery here at 8:30 in the morning. It's a tough time to talk, but glad to see so many faces here.
Okay, I'm going to open the floor for questions. Really? This is how it's going to be? Okay. Oh yeah, I'll pull a question. I don't have a problem with that. But
I have a couple of questions, actually. So the first question is for both the panel and the audience, and I just wanted to get everyone's opinion on giving the same repo order to multiple agencies at the same time, whether that's good practice, bad practice. I know none of my agents like it, so I don't do it, but I'd like to do it.
You've got a case out of Texas. I think the guy's first name was Tommy. Young man, 21 years of age, auto dealership down there, multiple assigned, and that's what that's called. First repossessor went out to the house. The man told him he wasn't going to surrender the vehicle, get off his property, and don't come back. The second repossessor went out to the house, said he was there to get the vehicle. The man told him, get off my property. I've already told him I'm not giving the vehicle up. Don't come back or I'll shoot you. 21-year-old man had a three-month-old baby, came back, hooked up to the truck. The man came out, fired 3 rounds with a 30-30 rifle through the back of the tow truck. It went about 100 yards down the road, went off in the ditch. The repossessor laid there, bled out, and died. In Texas, there's a law that says if anyone comes on your property after dusk, that you can assume they have ill intent and you have a right to defend with deadly force. No charges were filed against the consumer for shooting the man, but they filed charges against his wife for the fact that she saw it and didn't report it. And there is a law against not reporting a crime. The dealership was sued. I think they settled for $12 million. The man who shot him committed suicide with the same rifle. And, of course, the wife divorced the man. That's the worst thing that you can do is multiple assign. It gets people killed. In the input repossession industry, we don't want it done. We will not take an assignment, and if anyone gives an assignment and we find out that it's multiple assign, we'll never work for that person again. That's how strongly we feel about it.
From a legal perspective, I think you potentially also have liability under the FDCPA potentially, and maybe state equivalents. For example, in Florida, there's a particular statute that says if somebody tells you or your agent that they're represented by counsel, or that they won't pay the debt, or they're not going to, or leave because you come to repossess the car, then that knowledge is imputed to you as the owner of that debt. If another repossession company comes along, now you've done something with notice, similar to the trespass situation just discussed in Texas. So it would be impossible, I think, to convey that information fast enough to prevent problems like that from happening. And I think if it was my client, I would also want to err on the side of you don't want to have multiple people pointing the finger at each other if something goes wrong. Because that's what you'll end up with. 3 different repossession companies will be saying, that wasn't me, it must have been the other guy. And you don't have any idea, but you're going to sit there while they point the finger at each other. That never looks good, because then juries just pick somebody. We know something bad happened. Somebody must have done it. We'll just figure it out later. And as the person assigning that in Florida, it's a non-delegable duty. So you are liable for the acts of your agent in repossessing a vehicle. It's a strict liability situation in most instances. There's a few exceptions, but very few. So I just think it's a bad idea from a liability standpoint.
I think things have changed quite a bit. I think that just to dovetail into what the other panelists are saying here, from a collection standpoint, from a debt purchasing standpoint, we deal with something called overshadowing, which basically means it governs how you can communicate with consumers over a certain period of time. Overshadowing is, why can't I just assign my account to 4 different agencies? If 4 agencies are calling the same consumer in a week, I've got a better chance of getting that consumer on the phone. Well, unfortunately, with the rise of UDAP, which is Unfair, Deceptive, and Abusive Practices Act, which came out in 2010 and 11 to 12, it's really easy to take that application of that argument, and if you've got the assignment out to multiple repossessors, or you've got the same account out to multiple agencies, it's really, really easy for a consumer rights attorney to put forth a harassment claim against you. And again, I think Ron gave the worst case scenario, but really the more realistic scenario is you just get sued for harassment, and those are cases that are almost impossible to defend.
Okay.
I have a quick question for the audience, if you don't mind. I always like to get a better understanding of who's in the room. You know, how many people here represent independently owned automobile dealerships? Do we have any vendors in the room? I just like getting an understanding of kind of who we're speaking to in the crowd.
Okay. Buy here, pay here dealers in the room, show of hands. That's the overwhelming majority. Vendor personnel? Straight retail dealers? Okay, so we got one guy thinking about holding these notes. We got everyone else that holds their notes, and a few people that are trying to learn as much as possible about everything.
Love it.
Sound good?
Great.
Who we got? There we go, sir.
Yes, I'd like to ask each one of the panelists, what would be the number 1 and number 2 mistakes an independent dealership could do on repossessions?
I could probably talk for an hour on this. The two main things I see with respect to collateral, one is potential issues that arise after the sale. You get the vehicle back, and it's shocking the number of people that don't know how to dispose of a vehicle in accordance with the law once they actually get possession of it. Most states have adopted some form of the UCC, which was a treatise that was written called the Uniform Commercial Code, and there are some variations within the states, but most states require, after a creditor takes collateral back, that the collateral be disposed of in a commercially reasonable manner. And that's about the extent of the detail you get as to what that means. So then you've got to delve into some case law on those issues. For example, there's a case involving equipment from an equipment manufacturing company that was sold in Florida. It was repossessed and sold at an auction. A lot of people run their vehicles through auction. Well, that case says that's not a retail value, that what you get at auction is a wholesale value, and that the values can differ. So there's an argument to be made that if you're selling vehicles through an auction, that's not a commercially reasonable disposition because the fair market value for that vehicle is higher, and everybody knows that a wholesale doesn't necessarily constitute fair market value. So in that situation, clients are left with either doing the higher value of whatever Kelley Blue Book says, or the auction value, whichever's higher, and they report both to the customer. Under the UCC, once you get possession, you've got to give the debtor and anybody else that has an interest in the vehicle. So if there's a guarantor or co-buyer, they have to have notice of your intent to dispose of the collateral. And then once you dispose of it, before you can take any collection action, in Florida, you have to send them a notice of calculation of surplus or deficiency. And that's got to have certain things enumerated under the statute. And you have to be very careful with your notices of intent to dispose of collateral as well, because there's one for consumer debt, there's one for commercial, and they have different standards and different requirements. And then you also have another option, which is acceptance of the collateral and full satisfaction of the debt. And a lot of my clients that want to resell the vehicle on their lot, that's what they end up doing. But again, it's got to be a formal notice. It's got to have a time period. In Florida, they get 20 days after it's mailed to accept or reject. And if they don't object, then it's deemed accepted. So there's 3 different avenues right there for how you notify a customer you're going to dispose of a vehicle. And people either do a combination, or they don't send the letter, or they don't provide notice of the deficiency, and then something shows up on the customer's credit report. Well, that's a problem. So make sure when you're disposing of vehicles after you get possession that you're complying with the law and you check all the boxes. That would be my number one issue there. Yes. Well, there's different provisions. Like, for example, there are 2 additional sentences or notices that have to go into the consumer disclosure in Florida that aren't in the commercial. So if you send the commercial notice to a consumer, essentially there are 2 things that they're told. And one of them is that they have a right to an accounting. Under Florida's version of the UCC, and I think under most that I've read, you have to notify the debtor that they have a right to have an accounting. There's a case in New York that kind of started a trend. I had a client get sued in a class action for not putting the language in there that they have a right to an accounting, but sending an accounting. And the guy in New York did the same exact thing. A federal court said sending someone an accounting is different than telling them they have a right to an accounting. Therefore, you didn't comply. Therefore, you're liable. And the liability under the UCC, if you don't dispose of the collateral properly, is you can't collect the debt. The debt's void. The finance charge is liquidated damages and attorney's fees. So in a class action situation, you've got multiple finance charges for multiple customers from that one mistake in the letter. And the client ended up settling the case because the same exact circumstances was a class in New York in federal court, and the dealer lost. So we had very few defenses there. So that's just one example of one of the differences.
Mark, you have anything you want to weigh in on that?
You know, it's an interesting topic. To answer to the commercial, you know, it's for me, from a debt purchasing perspective, we're always, and whether it's commercial equipment or commercial leases, I guess the good news here, and I don't mean to make something minimal into a much larger discussion, but the majority of the commercial cases that we're seeing constitute such a small percentage of our accounts. Typically, we're looking to ensure that we are getting personal guarantor information, making sure the personal guarantor information is consistent through communications, and treating that with an application. For us, commercial is always a bit of a sore point because, again, my company, most of our members as an association take a very risk-averse approach, but there's still a large group out there, as I'm sure you can suggest, that will suggest that commercial accounts don't fall under FDCPA, and so therefore you don't need to follow those particular laws. That's not what I'm telling you to do, but that is a school of thought. Back to the original question, which is the number one pitfall. I'd say the number one pitfall is forgetting, at least this is what I try to teach our agencies, our law firms, the person we place these with. I think over the last 8 years, this concept of consumer-friendly collections has become magnified, whether it's the rise of the CFPB, whether it's the rise of unfriendly legislation, or things have just changed, as I think everyone can acknowledge. The human aspect. I think that making sure that your internal processes, and for us, again, we don't have direct contact with consumers. We're outsourcing to our agencies who have these contacts. But as the owner of these accounts, we're still the main conduit for a lot of the disputes or complaints that come as a result of purchasing these accounts. And oftentimes it's not the result of something we've done, but it's a complaint about something that's happened in the past, a complaint about I paid this and I never got this, or I was supposed to get this as part of a program and we didn't get this. One of the things we try to do is really maintain the fact that you can stop a problem from becoming a problem simply by listening. And it's those frontline people. We're not a huge company. We've got about 60 people. But any person that answers any phone calls, any person that maintains any of our catch-all email addresses, it's so critical that you listen. As you probably know, the auto account, the auto, whether it's a lease or a finance contract, is probably one of the last things that consumers let fall into delinquency. First go the credit cards, then go the installment accounts, and then go this, and then go that. But, they need that car. And so that's oftentimes one of the last things. So for us, I would say that, the number one thing you can do is don't forget the human aspect of it. Make sure that you've got people that are capable, that are listening, and that can mitigate that problem before it becomes a problem. Somebody that, everyone checks in the mail and this, that, and the other, but oftentimes you will run across that exception to the rule where having that 5-minute conversation, perhaps calling off a repossession till next week, saves you a ton of cash. I'm sure Mr. Sickles doesn't like hearing me say that because it keeps him well employed, but mitigate risk at every opportunity. That's my absolute number one thing to remember.
Mr. Brown? 2. Limit it to 2.
Something that we're seeing, and I have a lot of cowboy hats, but one hat I have is I'm the immediate past president of Santa Fe Railroad Credit Union in Oklahoma City. So I'm in the same position as you guys in a lot of things. But with the buy here, pay here dealers, something that we're seeing that's coming up is the consumer attorneys are saying if you repossess a vehicle, you recondition it, and say you paid $500 to repossess it, say you pay another $500 to recondition it, you put it on your lot and you sell it for $10,000. If the balance on that vehicle with the consumer, the original purchaser, was only $6,000, you owe the consumer $4,000 because you sold it for more than, and they're entitled to the difference. It's a crazy thing, but it's something you want to be very careful of, that you have stop gaps in there, and different companies that do different things. One that does it right sends out the notices, and we see a lot of money left on the table because the notices aren't sent out. I recently did a consulting job for a big dealership in Kansas, and they had like $3 million in deficiency balances sitting in a drawer that they weren't attempting to collect. And we looked at it. They had sent their notices out proper. Everything had been done proper, but they didn't realize they could collect the deficiency balance. And so they started working on those as collection accounts, actually put it together and sold it as a portfolio. Yep. So it's out there. Just be sure you do it right. And I think that's what you're hearing here. Know what your state law says on how you dispose of a vehicle. Follow the law explicitly. And if you sell it for less than the balance, go after the deficiency. But remember, if you put it on your lot and sell it for more than the balance, you may end up owing the consumer some money. Be very careful about that.
I'm actually going to add a couple here. Mistake number 1, repossessing your own cars. I can't tell you what a bad idea that is. That's kind of like doing surgery on yourself. Yet I guarantee, if I ask you to honestly, how many of you repossess your own cars with your own employees, There's going to be one or two brave souls after I said that comment, but there's people who are not raising their hands. Repossessing your own cars. Are you licensed? Are you insured? Are you bonded? More importantly, are you experienced? The reason you use an agent, in part, is to shield yourself from and add some additional insurance coverage. It's not, look, I get it. Nobody wants to spend money. That's also that something drives me nuts. You'll put millions of dollars on the street of your money, and you won't spend a little bit more to make sure you get it back properly. That just seems to be a blind spot among dealers. It's seriously, use a professional, licensed, bonded repossession agent. That's actually the second one's the paperwork, but you guys really hit that. I can't believe how many times I'll go to a dealership and ask, hey, can I see your last 5 charge-offs? And then I'm just holding the file. Where's the paperwork? What? Did you repossess these cars? Yeah. I don't have any proof. I've got dealers today that still don't know that there's disclosure notices that have to be done. It's amazing. These are not new laws, ladies and gentlemen. It's that we didn't take the time to learn our business. Who's next? Come on up.
Mine's more of a comment than a question. We've got 44 dealers across the country. And so I've been living with the CFPB for the last couple of years. One thing in repossessions that I had to change was the hold notices. So make sure if you take a payment and you've got it out for repossession, that you put a hold on it and get an acknowledgement from the repo company, because that was the only thing that they found that we had to work on, and so I had to fix that and stuff. So if the customer makes payment through Western Union or some other form, make sure you're getting a hold notice to the repo companies. Make sure the repo companies are acknowledging it.
Can I expound on that a little
Go
bit?
right ahead, Ron. I hope somebody would.
The lady is exactly right. And let me tell you something. If I'm hired by a law firm to come in as an expert witness, I consult with them on the questions they're going to ask you. Back to what was stated originally, one of the first things they're going to ask you is, if you used your own people, what training did you provide them? There's major training courses out there, field agent compliance training. It costs $19.95. And if you tell them we didn't provide any training, it's too expensive, then we're going to say $19.95. Is that too expensive? There's training programs out there you can train your people if you want to use your own people. Every case that I have worked where a lot has sent their own people out has resulted in a lawsuit sooner or later. A lot of guys that change light bulbs on the lot. So be very careful about using your own people. If you are going to use them, you're going to be asked to train. If you're using an agency, the first thing they're going to ask you, that I'm going to tell them to ask you, is how did you find that agency and how did you select it? I had a guy come up to me yesterday and said, what do you all charge to repossess vehicles? I told him, if you got to ask, you can't afford me. That's the first thing. You pay peanuts, you get monkeys. And that's what we see a lot of. When you assign an assignment out, you should get an acknowledgement from the repossession agency that they acknowledge they're accepting the assignment. That's standard practice with legitimate agencies. If you ask them to put an account on hold, you should get an acknowledgement, a time-stamp dated acknowledgement of what time that account went on hold. I can't tell you how many times I've seen cases where a payment is accepted and nobody bothers to call the repossessor. The consumer was hiding that vehicle because they knew they were past due. Now they give you a payment, it's sitting in the driveway. Repossessor drives by, hooks up, and hauls it away. You entered into an agreement with them. They can go back in court. There was an oral agreement. They complied with their part, made the payment. So make sure you get a time-dated acknowledgement from the repossessor that the assignment was on hold. Let me carry that over one more step. How long do you want it on hold? Don't ask those people to put it on hold for 30 days. They went out there, they did work. Pay them for what they did, and then reopen the assignment. And a legitimate agency, if they have to go out and repossess it, the original charges, they'll just apply that back against the total charges. But make sure you're using legitimate agencies.
I'm from Wisconsin, so we have breach of peace. I don't know if that's nationwide, but what is your opinion on, like, the debtor may come out, we try to do no contact, but it doesn't always work. They come out, they're heated, but then they calm down, they're like, oh no, okay, you can take it. But when they come up heated, we kind of treat that as a breach of peace. Can that be kind of thereby canceled or surrendered after that?
From a legal standpoint, I'm not licensed in Wisconsin, so I'm not sure what their standard is. I can tell you breach of peace is a fairly low standard in Florida. There are cases that have said if somebody just comes out and says stop, that you have to unhook the car and leave. You can't discuss it, you can't pressure them, you can't have a conversation. At that point, you just need to go. There are cases out there that say that's sufficient for a breach of peace, and some of it may be regional, it may be state driven. What's a breach of peace in Florida may not be a breach of peace somewhere else. There's some states that require notice too before you pick up a car. I had a client from Florida go and repo his own car in Massachusetts, and he called me and said he's got a lawsuit because apparently in Massachusetts you've got to give 10 or 15 days notice before you repossess a car. He had no idea. So he's like, well, what am I supposed to do? I was like, well, if you picked it up in Massachusetts, he's like, well, I just make a spare key for every car that I sell, and I have GPS. I just fly up, book a one-way flight, wait for the car, get in, drive it off. What's the problem? It's my car. I was like, well, it's not your car. You're a lien holder. I hear that all the time. It's my car. They didn't pay me for it. Well, yeah, but if you have a house with a mortgage, it's not the bank's house. It's your house. As long as you pay the mortgage, it's a lien. Right, exactly. And in Florida, that can take 7 years. In those situations where you've got possibly notice, possible breaches of peace, you've got to be very careful. And my advice would be just go get you can go and get a replevin order from the court pretty quickly in Florida. It's one of the things they'll process quickly, and the sheriff will go pick it up. And they'll say, if you don't give us the car, we're taking you to jail, because they've got a court order saying you're entitled to it. So my advice is err on the side of caution in those situations.
As far as Wisconsin goes, be glad for what you have now, because believe it or not, it's better than it was. It used to be no self-help repos under any circumstances, must have a replevin order, and it took you, they were 120 days past due before you could ever get it. It was a mess. Dot every I, cross every T. Don't you ever pick up your own vehicles. Always use an agent. And if you're in one state, don't mess with Wisconsin. It's got to be the worst of the 50. It's got to be number 50. You got another question? It's okay, guys. You can line up if you want. Got plenty of room.
So, follow-up question on the partial payment repossession. Do you think it's best policy to just not accept the money at all if your intention is to not stop the repossession? So, in other words, a customer calls in and wants to make a payment, and you tell them, if you pay this and not that, we're still going to pick your car up. And they insist on making that payment anyway. Should you just refuse to collect it?
That's what we recommend. We do a lot of work for credit unions and buy here, pay here dealers. And what we recommend is that if they contact you on the phone, if they want to make the payment, what you tell them is bring the car in. Once we've got the car back in our possession, then we can renegotiate with you. Several courts have ruled that if you do take the payment, it's going into a secondary agreement. And like if they were 2 months past due and you take 1 month payment, you have agreed to let them remain 1 month past due. So 3-4 months from now, they're making you a payment every month, but they're still a month back. You decide you want to repossess the car. You've entered into a secondary agreement with them, and the courts have said, hey, you should not have repossessed the car. It's wrongful repossession. Our recommendation is you wanted the car repossessed for a reason. Unless they can pay you current plus charges, and all contracts will basically say that they agree to pay the charges. If they want to pay you current plus charges, and really everybody goes away happy that way. You don't have to pay anything. You collected the money to pay the repossession agent. People still have their car and your account's current. That's what we recommend. Unless that, tell them, hey, turn the car over to the repossessor, let them bring it in, and then you come in and we'll renegotiate. That way you have a strong point to deal from.
You also run into potential rights to cure situations. Some states require right to cure notices to somebody if you've accepted late payments in the past. You have to give them 10 days notice and say, you're past due, we're not going to accept this. Florida's law is in flux on that issue, but I do know there's a consumer plaintiffs group that did a 50-state survey, and they sent it out to their members, which states have a statutory right to cure, which have a common law right to cure, and which are kind of up in the air. And for those of you that don't, there's both statutorily and common law, they have said when over a period of time you accept late payments, you've created a course of dealing with the customer where the customer thinks it's okay to pay late. So you can't suddenly hold them to the letter of the contract. You have to give them notice and a right to cure. Some states do require that, some don't, but if you take a partial payment, you would re-trigger potentially the clock to start to run again if you're in a right to cure state.
I'm going to answer it. Oh, sorry. If we have another question, let me answer it the best way I know how. Again, for me, I'm not boots on the ground. We're not talking to those consumers directly. But an interesting parallel that I'm hearing here, and I'm very familiar with these nuanced state-specific laws. For us, we deal with the statute of limitations in each state, which dictates how far since the date of last payment we can actively sue on an account. Common practice, I've been doing this for 20 years, and it's never been my practice to sue an account past the statute of limitations, right? So in California, it's a 4-year statute. In, Texas, 4 years. There's certain states that are higher, certain states that are lower. But at the end of the day, there's nothing illegal about suing past the statute of limitations, right? And so there was this practice going on for a long time where people were suing consumers even though the statute had expired because it's an affirmative defense, which means the consumer has to show up in court and say, they can't bring this action against me because the account is past the statute of limitations. You're hearing a lot of this, right? Is that there's a big difference between practice and reality. You can have something dictated and something can be legal to do, but as any either plaintiff or defensive attorney will tell you, they're the ones that are making the money here. And so when we start talking about these very subtle things, you need to make a decision internally and say, is it more important for us to mitigate risk as much as possible, or is it more important for us to get that partial payment on a $200 card that's worth $2,000? To me, we're going to take that path of least resistance every time because, again, just like I'm not going to sue past an account that's past the statute of limitations, the $200 on a partial payment, whether it's an auto account or not, in my opinion, does not retoll statute, just like that partial payment could essentially create a situation where a very creative plaintiff attorney is going to make your life miserable, and it's going to cost you a lot more than that $200 payment.
All right, thank you, gentlemen. Think you were next.
So, Rob, this is more of a question for you. Ron mentioned that, and this actually happened to me, where plaintiffs' attorneys, a lot of us probably recycle our repos. You get the vehicle back. I'm in Missouri. What I typically will do is either take the highest of MMR or Black Book wholesale. Is that commercially reasonable? I guess it's up for interpretation. But we were sued. Everything came out fine in the end. But that was the argument that they made, was that I sold the vehicles retail for a higher dollar versus what the wholesale value was. Again, it didn't go anywhere in this particular case, but what have you seen, I guess Missouri or other states, where that stuck, where there was a $6,000 deficiency, $10,000 resale?
Right. Well, if you do the acceptance of collateral, you eliminate that issue, because once you do the acceptance of collateral, you've told the customer, I accept the collateral in full satisfaction of what you owe me. It's now yours. You can set it on fire if you want. You don't have to account to anybody for anything. So if you really want to sell it on your lot, I suggest that's the way you notice customers, unless you're actively chasing deficiencies. Because I've got plenty of clients that say, I'm never going to collect on this. They don't try to chase their deficiencies, but yet they're disposing of the vehicles with the 10-day notice, the indication that they're going to sell it private or public, and then they're accounting to the customer for the deficiency, when in reality they could eliminate all that by just accepting the collateral. Courts are looking at that issue, and so are consumer lawyers. And I don't think giving credit for Cully Blue Book or whatever you pull as a source and just saying, well, that's fair market value, I'm just going to give you that, is sufficient. Because what the UCC says is you've got to give notice of the date that you're going to dispose of the vehicle. You've got to tell them whether it's a public or private sale. You have to tell them whether they can attend. And what the UCC envisions is a situation where people would sell something on the courthouse stairs, where you'd have a group of 4 or 5 people there, they're bidding, and that determines what the winner is going to walk away for that vehicle for. So just assigning a value to it doesn't necessarily establish what the actual retail market for that vehicle is. So I would just be cautious doing that. I think if you do the sale and you end up selling it wholesale through an auction or something like that, allocating the higher to the auction value or what you can pull as retail value off the internet, I think puts you in a better position to defend one of those cases, because then at that point you say, well, I only got $4,000 on the car, but I gave them $4,800 because that's what they said retail value was. So I think you put yourself in a better position to defend in that situation, because now you've done both. You've sold it, but you're giving them the benefit of the doubt.
Well, and so to kind of follow up with that, I don't go after the deficiency balances any longer unless it was an insurance, total wreck. If I don't recover the collateral, it's the only time I ever, because that's a hotbed in Missouri right now. They find one letter off of your notices, and you've got a UCC violation. The acceptance of collateral is not something that I've sent out, though. Is that every state?
That's going to be state specific. It's in the UCC as being one of the things that they recommended states adopt. So you just have to check in Missouri and see if it was adopted there. It's in Ohio, I know, and it's in Florida.
Okay. All right.
It was adopted in Missouri. I don't know the number of days you have to give them. Some states it's 20, some it's 21, some it's 30. They never object, ever.
Right.
Ever.
Right.
When if they do a voluntary, you can get them to sign an acceptance of collateral document at that point. Okay. And then it's immediate. You just waive the debt, they give you the car back, and a lot of people will sign that in a voluntary repo situation. You say, look, just give me the car back, I'll take it in acceptance of your debt, you just sign this paperwork and it's mine.
And then as far as reporting to the credit bureaus,
it's settled.
Yeah. Settled.
Yeah. They no longer owe you, they have no balance.
Okay. And what about 1099s at that point? I'm sorry if I'm hogging the mic, but I assume we have to send a 1099 then for that.
You'd have to talk to a tax guy on that. I mean, I think it's a
you
debt
have a 1099-C obligation for the uncollected amount.
Got it. Thank you, guys.
Unless you don't have a related finance company, in which case you don't.
As a follow-up to that, does anyone know if there's this form for California? Because we haven't used that before. Are you California?
I am California. I couldn't hear your question though.
The acceptance of collateral, is that something that's in California?
I can tell you that the People's Republic of California is it's a difficult place to run a business. I can only speak from experience. Again, Ron's probably forgotten more about repossession law than I've ever known. With that being said, I can tell you that as a company perspective, we take a very interesting approach on a notice of repossession. As they indicated, we indicate to our agents that we want them using the highest number. So we'll send out a 30-day notification of repossession, just like we'll give consumers, even though they may only have 10 days right in the state, we'll give them whatever that state allowable maximum is. It kind of throws a wider net. I can tell you in California, in cases of voluntary repossession that we've been involved in, we're typically from a commercially reasonable perspective. And again, the volumes that we're involved in are certainly not on the same levels as a major bank originator. We're probably picking up 1,000 vehicles a year, 1,500 vehicles a year. But for us, I can't speak specifically to that notice, but I can tell you that California is just a very, very consumer-friendly state, and so for us, we try to make every commercially reasonable effort to effectuate a voluntary repossession, so that there's less chance of that opportunity for awful litigation to show up a week later.
Okay, thank you. My follow-up is, what do you guys do when the registered owner calls and complains about your repo company that some property has been now gone and thousands of dollars they were in the glove box or something like that? How does that get handled usually?
So you personally, and I think this ties back to a question we were talking about earlier, is how do you ensure that your downstream or agencies or repossessors are doing what they're telling you you're doing? I think it actually tied out to the repossession hold question that was asked earlier. all of my vendors, clients, agencies, law firms have a master servicing agreement that's in place between us and them. My master servicing agreements also contain work standards, expectations. These are things that cover everything from how many times can you contact somebody to can you email someone, how many right party contacts do we expect as the owner of the account on our accounts. I believe that a lot of this really is dictated by the arrangements that you have in place. Furthermore, it's a protection for both parties. Indemnifications are within our contracts, protect both our repossessors we're placing accounts out with. If there's something wrong with the data, they go out there and repossess something. We told them to do it. It's our fault. If they go out there and punch somebody in the face, clearly I'm not responsible that's happened. So these indemnifications work both ways. I hate to, it's a bit of a cop-out answer, like, well, it's in the contract, but truly that's something that I've learned is that, just as you had indicated earlier, look, if it's not in a contract, if it's not in a file and you can't refer back to it, you may want to look at that as a definite process improvement internally.
There is a industry standard contract for repossession agencies that covers what he was speaking about. I'd be happy to furnish you one with that copy. Just email me. I'll email it back to you. Once again, and it goes back to the fact that, understand something. Within the credit, within the lending process, within the automobile sale process, the most dangerous and litigious area is the area of repossession. You are going onto someone's private property and taking something that they think is theirs. So many things can happen. The breach of peace. There's no black law definition for breach of peace. You have to look at what the courts have said is breach of peace. And as was clearly stated, if anyone says stop, you better stop right there. When you're paying someone and asking them to work contingent, no metal, no money. I've heard that many times. Wisconsin is terrible. We had a case up there where the guy went out to repossess the vehicle, hooked up. The guy came out and said, I'm paid current. They call the client. The client says, they're current. Do not take the vehicle. The repossessor said, if I don't take your vehicle tonight, I don't get paid, and I'm getting paid tonight. That's in the deposition that he said that to the guy, and he admitted he said it. Took the vehicle. You got to be careful who you hire. There's two major national organizations right now, the American Recovery Association and Allied Finance Adjusters. Both of them vet their people very carefully. ARA has a red light, green light, yellow light. You can look at the agent and see how they're in there. If they're not a member of a national organization, I would tell you be very cautious using them. If they give you copies of their license, which you should request if it's required, copy of their bond, keep copies of that and don't just take them, verify them. We had a case in Arizona. They gave the people all the right documents. Turned out they had forged them. They'd take somebody else's insurance accord, put their name on it, taken a license that was expired and updated it. You have an obligation to look at who you're using, and it's going to come back on you if you don't. And again, that industry standard contract covers all of this. It's got the hold harmless in it from both sides. You give me bad information, you help me. I do something wrong, I take care of you. Again, anyone who wants a copy of that, I'll be happy to send it to you. My email address, if anybody wants, it's rbrown@csi-arm.com. rbrown@csi-arm.com. We've got 498 pages of compliance documents that are required by the CFPB, and it's amazing the things that we have to go through. A legitimate agency, but you're a lot better off to pay a little bit more up front than pay a whole lot on the back end if you get involved in a lawsuit.
So when you accept the collateral, does the customer waive their right to any surplus?
Yes. Essentially, you take the risk that it's worth less. They take the risk that it's worth more. So, what it is in its easiest explanation form is it's just an agreement that, I've got a lien on this chair, and I'm going to take the chair, and I'll release you from the debt, and the chair is mine. I can do what I want with it. And it's codified in the states that have adopted it. So it's really, and again, talk to a lawyer from your states before you try to use the form. Don't go online and just download the form, because there may be certain notice requirements if they've paid 60% of the cash price in Florida, you can't accept the collateral in full satisfaction of the debt. 60% of the cash price is 60% of the principal balance. The interest doesn't count because the interest is the cost of delaying payment. So, you've got to make sure that it's available to you. But like I said, there's a limitation in Florida in that form. Other states may have similar limitations. So talk to somebody local and make sure that you get a good form and that you know how to use it.
And can you pick and choose on those? These accounts I can, these
Yes.
accounts? Okay.
You can use it whenever you want, however you want. You don't have to use it one consistently the entire time.
Can I add a little caveat to that? We get things all the time from banks, credit unions, buy here, pay here dealers, new car dealers, asking us, when you repossess this vehicle, have the people sign this form. Have you ever been out there at 3 o'clock in the morning with the key to the vehicle, and if you knock on their door at 3 o'clock in the morning, it's a violation of the Fair Debt Collection Practices Act. If you're using a tow truck driver to repossess, we have what we call the tow truck driver syndrome. They don't know how to talk to people. They're tow truck drivers. They drive by the address 100 times. The vehicle's not there. They never stop and knock on the door. If you're going to get a document like that signed, you've got to be using someone who knows how to explain the document and know what the state law is. And again, it goes back to using a professional and explain to them when you give them this why you need that document signed. So they know we're going to have to go in the afternoon. We're going to have to make direct contact with the consumer. We're going to have to ask them to surrender the vehicle. This is not a self-help steal in the middle of the night with a tow truck type situation. If you're going to use a document like that and you want to use it, we don't have any problem getting the document signed, but all we can do is ask the consumer to sign it. Many times I've had them tell me, hey, I'm not signing anything. And it frees them from the liability. They just don't understand it. And even when you explain it to them, I'm not signing anything. Just take it or get off my property. That's what we get when we get out there. So if you have a repossessor call you back and tell you couldn't get it signed, understand they may have tried and the consumer just wouldn't sign it.
You've got to be careful in those situations too, because what will happen is the customer will come to pick up their personal effects or their personal property, and the company will say, well, you got to sign this form in order to get your stuff back. Now they've agreed, they've signed the acceptance of collateral or the waiver or whatever it is you're getting them to sign under pressure that they weren't going to get their property back, or at least that'll be their story by the time they talk to a lawyer and take legal action against you. So my suggestion there is you would want to deal directly with the customer on that kind of stuff if possible, just to prevent anything from like that from coming up.
All right, me again. Along the retrieval of the property, I've been told by the state of Missouri that it actually is illegal to charge the customer to retrieve their property. And I don't know if that's a state-specific thing, and I know it's a pretty common thing with repossession companies to do that, to charge to...
That's going to be state-specific.
Okay.
I see that all the time. I see fees get added in. Somebody will come to redeem their car and they'll say, okay, well, there's a $350 tow fee, there's a $50 gate fee, there's a $150 administrative fee, so you've got to come up with $500 to get your car back just to pay off the tow company. And then you look in the contract between the lender and the tow company, and there's no right to a gate fee or an administrative fee. There's a $300 or $350 flat fee. So both now the lender and the tow company have committed an unfair and deceptive trade practice, probably some kind of a debt collection violation, and they're going to get sued by a consumer that's going to go talk to somebody and find out that they paid a bunch of fees they didn't have to.
And I know that's, again, in Missouri, I'm sure it's most other states, we can't upcharge, if it's $350 to repo, I can't charge $400.
Right.
It's more about if the customer wants to go to the repossession lot, can the repossession agency charge $50? And that's Ron.
In my opinion, I don't think they could, because under most contracts, the person who has defaulted is going to be responsible to you for the costs of recovering the collateral.
Right.
So now you've got a third party making additional demands to get their collateral back, when in some states they've got a statutory right to redeem. Like in Florida, you can pay off the balance owed on the loan and take your collateral back today. If I come in and give you 10 grand, you give me my car. I mean, that's the law. So when you start adding these fees on, because the repossession company feels like they can, you're going to be on the hook for that as the lender, at least in my opinion.
Something you want to be extremely cautious about there is, in a lot of cases, if I work an assignment for you, I agree to give you 10 days free storage. Okay? That's kind of a normal thing right now, 10 days free storage. If the consumer comes in, a lot of companies will charge the consumer the storage fee. Well, we as repossessors have no contractual agreement with the consumer. Our contractual agreement is with you, and your contract says that they will reimburse you for whatever charges you have to pay. Well, you don't have to pay the 10 days free storage. So if they're collecting the money from the consumer, it's a UDAP violation. I can't charge the consumer something that I'm not charging you. So I've got to give the consumer 10 days free storage. So if you see a contract from a repossessor, or if they tell you they're going to charge a redemption fee, do they charge you a redemption fee when you come to pick your vehicle up? Then why can they charge it to the consumer? Do they charge you storage? Do they charge you a fee to cover their personal property and inventory it? And actually right now, a lot of the major lenders, Cap One, they actually pay the repossessor like a $25 fee that they're able to bill Cap One to inventory the personal property. You know, when you pick up a car and the people have been living out of it, you know, you got 26 bags of personal property that you've had to wear hatch gloves to go through because there's needles and stuff. $25 doesn't even begin to cover it, but that's the deal, you know. So, you know, it's very important that you understand with the repossessor you're using that they're not charging the consumer anything that they're not charging you, because it goes back to UDAP, and you're the deep pocket, and you're the person that's going to be looked at.
If your contract doesn't say you can charge it as a dealer, don't. I've seen more than one dealer claim they had a right to charge a convenience fee. That's what they called it, a convenience fee, because I had to repossess your car. You're charging interest, and you know, come on.
We run across these things quite frequently from a lot of smaller businesses looking for collection services. A standard contract, and this could be anything from the kung fu school down the street to your local gym, it doesn't really matter, but it's all applicable. You'll see language in contracts that the consumers are signing that says, if this account goes delinquent, it may be placed out with a collection agency, and you may be responsible for those additional fees. And here's where it gets really squirrely. A lot of clients try to take the application of the collection agency, right? A collection agency takes a rate when they collect an account. Let's say it's 30%. Clients, and it's happening less now than it has in the past, but clients are actually adding 30% to their accounts and placing the accounts with the 30% balance. And so, again, right, I've said it 3 or 4 times. I know we're kind of getting close to the end here. If there's one piece I'd leave with y'all, mitigate risk as much as you can. In this particular instance I'm using, if your contract says we will charge a $10 fee if we place this at an agency, I think you've got a much stronger legal understanding. It's the nebulous language that gets you in trouble. Convenience fees of an unknown amount. Let me tell you, I don't care if your contract says it. If you charge it, you're making yourself a target for the CFPB, for the regulators and the big boys looking to make your life miserable.
You've talked about a lot of making sure the document is correct, and everybody's in different states. Our customers go to different states. Where can we go as a finance company, for me, if someone goes to Oklahoma or to Nevada, to make sure that we're sending out the proper documentation, because I can't send Delaware literature, Delaware finals, or a right to cure or whatever, because if they moved. So where do we all go to find the information that we're sending out the right documentation so we don't get sued?
I mean,
self-promotion?
No, I mean, I only practice in certain states, so I wouldn't be your source. You know, there are forms companies out there that you can, look to. Some of them have statewide or national software. The other source I would say is state associations. I know through FIADA, the Florida Independent Auto Dealers Association, I act as their outside general counsel, and I'll get calls probably once a month from somebody out of state trying to find out how they can repo a car in Florida or how they can do whatever. And I'll answer the question for them. I'll take 10 minutes to have a conversation with somebody. So that would be another source, but you've really got to be able to trust that source, whether it's a forms provider, whether it's a document bank, or a vendor. If you've got an attorney, that attorney can probably figure out what the law is in Montana if you've got to go there, just by looking at their statutes. So, that's another source, I would say. And if a lawyer does it for you, it gives you an extra layer of insulation.
I have one word: Google. That's the way, if you use a repossessor in a particular state, they will have some knowledge if you're using someone out of one of the directories or something, but it will be basically what the laws are related to the repossession, not the laws related to the documents you have to send out afterwards. Something I have found very helpful, because I've had clients call me and say, hey, we repossessed this car in Kansas. Kansas has a right to cure 20 days. What do we have to send out now? We would refer them to a dealership that we have a relationship with in Kansas, and that dealership would basically have someone in their F&I department that would know what documents needed to go out. That gentleman, he's just full of questions, isn't he? The kind of guy we like.
Regarding going back to the voluntary versus involuntary repossession, we process both voluntary and involuntary repossessions the exact same way. Do you think that's good policy or bad?
That's a tough question to answer without actually looking at your policies. I would say that if the policies themselves were consistent, outside of a voluntary versus involuntary, the fees were clearly defined and the indemnifications were in place. I'm not... I need to see it.
Just to give you an idea of what we do, we have all the proper disclosures. They all go out at the proper time. We send every vehicle to the auction. We don't ever keep a vehicle. We don't ever put a vehicle back or send a vehicle back to the dealership as the RFC. So, again, our process is, we follow the exact same process, whether it's voluntary or involuntary. So the bottom line is we go after the deficiency either time. It doesn't make any difference. And I'm wondering if in a voluntary situation, if it would make more sense to keep the collateral as payment in full and not go after the deficiency on just those accounts. Or am I better off just having a policy that encompasses everybody so it's the same way every time?
In my mind, that's really a business decision as to which approach you would want to take. From a liability or legal perspective, as long as it's compliant, that's fine. I think you could use the voluntary surrender option with an acceptance of collateral as a carrot, but again, that's a business decision. The only problem is you can't threaten somebody to sue them or try to collect a deficiency if you don't intend to take that action. So if you tell somebody, look, you've got to do the acceptance, and if you do the acceptance in the voluntary, I'll just accept the collateral. If not, then I'm going to come after you and I'm going to chase you. You actually have to intend to do that. If you don't, then that's a FDCPA violation and probably an unfair deceptive trade practice violation in certain instances as well. So keep that in mind.
Okay, we got time for one more. JT.
My question is, on the redemption process, can you just charge what they're past due and the fees, or can you charge more than that? Let's say you want to get the balance paid off. Escalate to get the car back.
Well, that's going to depend on your state statute. In Florida, you are not required to allow them to just pay the outstanding balance. They have to pay the full total amount due on the loan once you repo the car in Florida. But I've got plenty of clients that say, you have two options. You can pay in full, or you can pay these fees plus this by this date in order to get your car back. So I don't know what state
I'm Michigan, so.
Okay, yeah, I just don't know what the laws are in Michigan. I would talk to somebody up there, but typically In my experience, the laws are you're not required to let them get their payments current. They've already broken a promise with you, and if you let them have the car back just by getting their payments current, there's a chance they run off with it. You might never see it again. So most state laws that I've looked at have the absolute, you got to pay off the full thing. Now, again, I don't know, there might be particular consumer-friendly states that allow that, but that'd be something to look at locally.
All right, thank you. Ladies and gentlemen, I encourage you to refer to your books and refer to the app. There's a lot of great contact information for these content experts. If getting people that know this much about repossession law on a stage at the same time wasn't easy, give them all a big round of applause. We've got a break set up from 9:30 to 9:45. 9:45 is the next set of sessions. And I believe after that is, I think they got like a lunch or something like that. But thank you all for coming. Appreciate it. Thanks for getting up so early.